Contented Media presents Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, an original podcast series with Mark Hunter and Arthur Van Pelt.
Hello and welcome to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, the podcast that takes a razor-sharp scalpel to the Craig Wright story, dissects it with utmost care, and extracts the juiciest bits to feast upon. This special bonus episode touches on a storm that has been steadily brewing ever since Craig Wright signed that famous deal in 2015 that would result in the birth of nChain, and which, more pertinently for us, would see Wright create a mammoth blockchain patent portfolio. As anyone who has followed the Craig Wright story will know, Wright puts huge store in this broom cupboard full of blockchain patents, with nChain now boasting over 1,200 active patents and pending applications. Having spent years amassing these, Wright has recently announced that he will start enforcing what he perceives as patent violations, claiming recently that he's not aware of a single blockchain or cryptocurrency that is not violating his patents. In fact, here's a clip from a CoinGeek conference in July where he discusses his next steps.
That's my offer at the moment. I mean, this is the carrot and the stick. The hard way, easy way, I don't care. It's going to happen. There's no one I know of who isn't breaking an nChain patent at the moment in this industry. And I can't go after everyone at once. I mean, we can do one or two a year, and we'll start with the big ones. So the small ones might survive a little while. But I might randomly pick a small one to pick on.
It seems that this looming patent war may soon be upon us, so joining Arthur and I today is a man who knows an awful lot about this aspect of the Craig Wright saga, having looked into it for a fair old while now. We're delighted to welcome David Pearce, aka Dr. Tufty Silvestris, to the Dr. Bitcoin podcast. David, good to have you here.
Thank you very much, Mark. Tufty used to be a secret, but has not been a secret for quite a while. So yeah, I'm happy being mentioned in both names.
I was going to say, you're not doing a great job of keeping it secret.
the OPSEC used to be better than it was. I have a story about that, but maybe if we've got time, we can go over that.
Cool, excellent stuff. Okay, so we're here to talk about patents. Before we get involved in the whole Craig Wright patent saga, can you please give us a bit of information on your history, your background, how you got into this, and what your connection is with Arthur?
Okay, well, my background is probably not what you expect, other than back in the early 80s, I was obsessed with programming my ZX Spectrum, so that puts me in a certain age bracket. I did an engineering degree, couldn't really find a job, so I got a PhD in high temperature ceramic materials, so nothing to do with computers. Stayed on after my PhD and spent a few years doing postdoc research into piezoelectric materials, and that eventually led to an invention. So it's the first point towards where we are now. I invented a thing that got called the Heliomorph. It's a super helical piezoelectric actuator.
Oh, what are those?
One of those, yeah. And it got bought out by a startup company in Cambridge. I suppose what led to me becoming a patent attorney in the end was there was a dispute over the IP and how much I got paid. In fact, it all comes down to money. Mm-hmm. But as part of that dispute, I got interested in the patent law side. And a friend of mine suggested, why not become a patent attorney? My response was, well, don't you need to be a lawyer? And she said, no, you don't. You need to be an engineer like you are. So I changed career in my early 30s, became a patent attorney in sort of early 2000s. Didn't really see or pay any attention to Bitcoin until around about 2017, I think. Mm-hmm. I think it was probably the Andrew O'Hagan article that got me interested in it, and I got further interested because nChain started filing an awful lot of patent applications. So lots of people in the patent profession pricked up their ears and thought, who's paying all this money for? Literally hundreds of applications started appearing on the UK Patent Office register. Mm-hmm. We couldn't tell what they were because it takes 18 months for them to publish. But over time, I kept an eye on these things, and it sort of led towards, as they were getting granted, I was thinking, okay, if these are interesting, where's all the interest? Who's paying interest to these patents, and why is nobody opposing them?
Mm-hmm.
And that sort of takes us up to 2021, I suppose, when I contacted Arthur.
Yeah, I think it was there. We are related for like almost 2 years, I guess, 1.5 at least. What do I remember from back then? I was always sending you links and tweets and news, and yeah, we just stay in touch. And at some point, it grew to the point that where we are now, that you were thinking, I think I found a patent that we can do something with. And you came with a proposal.
That's what came up in 2021. I was looking around to see, well, is anyone interested in this space, and is anyone thinking about trying to attack or at least question some of these patents that nChain was getting.
If we look at, first of all, a patent in itself, what are the pros and cons of a company like nChain obtaining a patent for something it's created?
If I just go over a couple of basics about what a patent is,
mm-hmm.
If you come up with an invention, you get a limited monopoly for that invention in return for telling everyone about it and importantly telling everyone how to do it. And the second important point to know about a patent is that all it allows you to do is to stop someone else from doing what the patent says. It doesn't allow you to do what the patent says. It only allows you to stop other people from doing it.
Mm-hmm.
So the benefit of a patent is in the ability to stop people, and therefore if you say, I want some money from you, otherwise I will stop you doing that, then what you have to have is an invention that other people want to use. That's the usual benefit in getting a patent, because it gives you the ability to get a return on an investment that you've had to make in getting to the point of commercializing something. So it might cost you a lot of money to develop a new widget and to bring it onto the market. If you bring something onto the market and then someone else could look at that and just go, well, I can just copy that without having to invest the amount of money that you've invested. That's the basic reason for having a patent system.
Mm-hmm.
The cons really come in when doing that is less costly. So if you can just sit down and rattle off an idea and get a patent for it at very little cost and cover something that someone is either inevitably going to do or is developing, or you've just come up with an idea and not invested anything in it, but you can then go and stop other people from doing it, then you're getting into the realms of, this is not necessarily a benefit. This is not an overall benefit, a public good. And this is where you get into the area of patent trolls. They're people who have not necessarily invested much in developing their patents, in developing their inventions, but then use those patents to extract or extort, people would say, money out of people who they allege infringe those patents.
Mm-hmm.
If you look at it objectively and take a step back at what nChain are doing, what they look to be doing is, they're building up an enormous patent portfolio and they're clearly investing a lot of money in all sorts of different areas around blockchain, etc. Well, that's fine, isn't it? If they're developing lots of useful inventions and patenting them, then they're using the system for what it's designed for. But that's not the whole story, is it?
No, not at all. So, David, could you talk us through what nChain has to go through when it applies for one of these patents, please?
I've got one in front of me. I don't need to go into the details of which one it is, but we've got a European granted patent in the name of nChain Licensing AG, which is a Swiss company. That's what they've been doing recently. All their patents have been assigned to a Swiss company. It was a company in Antigua, not the UK. So nChain is based in the UK, but the company was based in Antigua, and now they've assigned their patents to a Swiss company.
Mm-hmm.
So they have a European patent that originally was filed in February 2016.
Wow.
So it can take quite a long time for these things to get granted. and the one I'm looking at was granted in September, so just a couple of months ago. A patent application, if you keep it going from filing to grant, at around 18 months after the filing date, you have an A publication, which is just what the applicant's filed. So it's not what's been granted, it's not what's been examined necessarily. And then after that, it gets examined properly, and the applicant usually has to make some amendments, has to argue the case with the examiner. It goes back and forth a few times maybe. And eventually, if it gets granted, you get a B publication. And that's the granted patent. So normally what you get is the claims get limited. So what you originally claim might be very broad. The examiner objects to that and says, no, I found something that covers that. It's in the prior art. And then you go, okay, well, I'll add another few features and get around that prior art. And then the examiner goes, okay, we'll grant that. This whole process can take a few years. This application, this granted patent I'm looking at, so it's a European granted patent, took over 6 years to be granted. I can also look at where it ended up elsewhere. So it's like a tree branching off in different directions. So you end up with a family of patent applications and patents. And what normally happens, and I think this is what happens in all nChain applications, it's quite common, is that 12 months after they file a UK application, they then file what's known as an international application, which then gets searched by the International Searching Authority. And then after another 18 months, they then decide which countries they want to prosecute that international application in. And in the one I'm looking at, they've gone into China, Europe, Japan, Korea, and the US. And they also have one granted in the UK. I'm not sure how they got that, but yeah. So they've gone in the major jurisdictions that will be quite common for big companies.
Would it be fair to estimate that each patent is from the creation, filing, publishing, granting, and then refiling and pushing them into other countries? I once read a number, and I think it was mentioned by either Kelvin Hare or Craig Wright. I remember a number of $70,000. So sometimes when I talk about it in public, I say between 50 and 100,000. Is that a fair number, you think?
I think for that number of jurisdictions, so you're looking at USA, Japan, Europe, China, maybe a couple of others. Yes, 50 to 100,000 to get to the point we are now. So maybe 5 or 6 years down the line, you will have spent certainly between 50 and 100,000, probably more.
For one patent we're talking about.
Bear in mind the distinction between patents and patent families.
Right.
So you have, like I said, if you consider the original UK application, the root, that establishes the patent family, and then that branches out into as many different countries as you want to file in. And that patent family, they all become separate patents, but they all have a common root. nChain will say, we have thousands of patents and patent applications. Okay, but you have only 350 patent families. It's still an awful lot, but you consider the number of inventions effectively versus the number of patents. The number of patents can be enormously larger than the number of inventions you have. On just a simple search on the European Patent Register, I get 361 applications and patents in the name of nChain.
Mm-hmm. And so when we have to multiply and make a guess of how much nChain, Kelvin Hare, is spending on this stuff, it's like 360 times 100,000, maybe even plus.
I was thinking of a ballpark figure of how much you'd have to spend per year, and it's got to be several million per year just keeping this going.
Right.
So back in 2015, when Craig Wright signed this deal as Satoshi Nakamoto, quote unquote, the idea was, to quote from, I think this is from the Satoshi affair, either Stephen Matthews or Robert McGregor said that the idea was to package it all up and sell it and never to operate it. Now, can you explain what that means in real terms?
I can explain it in normal terms. Like if you're thinking of this like a normal company, a normal operation, that would be like the way a university would operate. So you wouldn't consider a university to be a patent troll, but what they do, universities hardly ever, unless they spin out companies, they hardly ever commercialize themselves, their inventions. What they do is they might get a few patents and build up a portfolio that they can then license or sell to an interested party, and that's fine. Nobody objects to that sort of behaviour. Then that's effectively what nChain have been doing. So they've been pumping obviously lots of money into getting inventions out of Craig and others. There are lots of other inventors that have been named on these applications, and on the face of it, that's absolutely fine. What they must know what they're doing. They must have some sort of strategy that these are going to cover an overarching goal, and then someone's going to want to come along and pay them a lot of money to license this.
Yeah, in the Satoshi affair, numbers of billions were mentioned. Upward of $1 billion, I remember.
Yeah, taking a more sceptical view, probably taking off my patent attorney hat a little bit, having had a look at some of these patents, there's an awful lot of stuff that just seems incredibly obscure and varied, and it's all over the place.
I spoke to a guy who worked for nChain for a couple of years, about 3 years I think he worked there. This is the quote he said to me. He said, also, the inventions in nearly all of these patents serve no real business use case. They are essentially obscure ways to shoehorn parts of the Bitcoin tech stack into other technologies. And it seems like what you're saying, David, kind of backs that up.
That makes actually complete sense. Yeah, I'd certainly see that. But the common theme seems to be that there's an awful lot of obfuscation there. This is what I think nChain has been doing, and really it's Craig Wright leading this. It's throwing lots and lots of obfuscatory sounding stuff, technical sounding stuff, at the wall of the patent system with a view to just going through the system and making it appear like you've got lots and lots of interesting inventions without actually having anything really in substance. But it's all described in such a way that someone who reads superficially these patent applications would immediately think, blimey, this is complicated stuff, and they must really know what they're talking about, and these guys are genius. But I've gone into reasonable depth on a few of these, and superficially on a lot more, and the ones I go into depth, the more I read into them, the more I think there's not really anything there. So my gut feeling now is that what they're doing is that the purpose is just to keep the appearances going so that whoever's funding the whole project can keep on throwing the money at it, which is, as we know, it's Calvin Ayre. How long that can go on, I don't know. It's baffling me that it's gone on this long.
Arthur, given what we know of Craig Wright, doesn't that just fit the pattern to a T?
Oh, absolutely. This is Craig Wright. His signature moves in the Bitcoin industry. This is how he is. When I watch his videos, for example, when he is explaining the Bitcoin white paper, he made several videos about it. The BSV fans, they love it, and when I look at it, after 10 minutes, I'm already bored. He's not explaining anything. He's just rambling on, and he knows the jargon, he knows the nomenclature for the bit, but he makes a lot of mistakes when he's talking about it, and it makes no sense. Only for the superficial listener. It might make sense, but I'm not a superficial listener for many years already anymore, so yeah. So the patents fall in the same scheme, I guess.
I think the difference with the patents is that it's not just Craig that's doing this. He's thrown a lot of his ideas into this system, but he's got other co-inventors who may well actually know what they're talking about, and they've involved some pretty clever patent attorneys who have, it's probably not right to say cobbled together, they've assembled these patent applications in a way that, as you would have to do as a patent attorney, you make it into a coherent whole. You make the thing make sense. Presumably, you've gone through the process of asking questions and making sure that the patent application looks sound. You don't know what the original invention disclosure was, but it's been polished and refined and then filed as an application and then comes out the system a few years down the line. And you don't know what's gone on behind the scenes to get to that point, but you can kind of get an impression based on the sort of bag of features that you tend to see in a lot of these, where it's all a bit arbitrary, and the ones that they have got granted. Andreas Antonopoulos' book, Mastering Bitcoin, which was published in 2014, that gets cited quite a lot. The Joseph Poon paper on the Lightning Protocol gets cited quite a lot. And a lot of them are, well, this is just this feature in Bitcoin with an alternative twist, or with a new feature that's just strikes me as being, well, that's just a bit arbitrary. No one's going to want to use that.
What is your impression when you go through all these patents? I mean, let's say you have seen out of the 360, what do you think? How many did you have a more than superficial look at?
Well, I've only looked so far at the ones that have been granted.
Right.
Because I think, well, while they're still pending, before they've been granted, basically anything can happen.
Is your impression that any of them can or will lead to working products that the industry as a whole can use?
It's difficult to see. They're patenting things all over the place, so it's difficult to see a coherent theme in all of these anyway. I mean, I've probably looked in reasonable detail on maybe a couple of dozen of these granted patents.
Mm-hmm.
There are 57 European patents that have been granted. I've superficially looked through most, if not all of them, just seeing are there any obvious ones to have a go at. And, well, the two that I've looked at in the most detail, one was from last year where the patent relating to that involved a variation on communication between nodes. So we know the Bitcoin network operates using nodes, and they communicate with each other. All transactions get sent to all nodes. And this was a variation on that, saying, well, we want some nodes to be special nodes and other nodes to communicate using encrypted links with other nodes. And reading it, I was thinking, well, this is not something that anyone would want to use. Eventually got involved with an expert who did know about that particular field, and he said, well, this is just a variation on this paper from 1990 or whenever it was. I think the difference was the private key was shared between the nodes. That was it. Otherwise, it was the same as what was disclosed in an earlier paper from 20 years previously. But it got through the system because there was this extra, essentially arbitrary feature that they could persuade an examiner that it was new, but you can add any feature and you go, well, this is new because it's different over this document.
And David, is it your impression then also that when they file these patents, because they are mostly, if not all, I guess, they are blockchain related, and that field is of course quite new. Is it fair to say that those examiners at the patent registry offices, they have no knowledge or they are not experienced in that field? They are likely to approve or grant a patent in the blockchain industry?
I think maybe earlier on that might have been the case, but certainly at the European Patent Office, they're pretty good. At the European Patent Office, you have examining divisions who are expert in a particular narrow field, and that those are the applications that they will deal with. So pretty quickly, once a new sort of field has become established, those particular examining divisions will know what's out there. So you might be able to get a couple past them early on, but then they'll quickly be up to speed on what's in there in that field. And I've seen on looking through the prosecution files on lots of these, you see the same papers coming up again, and examiners know where to look, and they've cited Bitcoin improvement protocols and things on GitHub and things on Wikipedia and all sorts. They know where to look for the prior art. So you might be able to get the initial things past them, but where we are now, I think it's a fair fight, more or less.
Yeah. No, but that suggests to me that when Craig Wright is saying and he's promising like 20,000 patents in his lifetime, that will be quite hard for him, if not impossible.
Well, it's got 57 Europeans so far, so at the current rate, that's going to take quite a while.
How many lifetimes is he going to live?
Yeah.
I mean, it's impressive for anyone to get that many European patents, so I don't want to knock him for that. But yeah, 20,000 it's a bit of a stretch.
Is it a case that the deeper you go with it, the more specific you get with a patent, the less chance you have of anyone actually wanting to use it?
Well, the less chance there is of anyone infringing it, which I suppose is saying the same thing.
Mm-hmm.
To take the example the one I looked at last year in detail, if anyone was going to want to pay to not be sued on that patent, they would have to be doing something that's very, very specific, involving shared private keys and bilinear pairing operations and map-to-point hashes and all sorts of really quite specific things that no one in their right mind would put together and actually use in practice, at least as far as I can tell.
From your knowledge of blockchain, do you know if, as Craig Wright says, there is no blockchain, there is no cryptocurrency not infringing my patents? I mean, how accurate do you think that statement is from what you've seen?
I've been looking out for, I generally ignore a lot of what Craig says, but I pay attention when he makes specific allegations on specific patents. And he's done that a few times.
Mm-hmm.
He's claimed that such and such a patent covers lightning. So immediately I then go and look at that patent, and then obviously it doesn't, because it's got a specific feature that had to be added to claim 1 to get it over the line to get granted, which means that no one would need to infringe it. So that's usually the case. So the thing that they have to add to get it granted means that it won't cover the thing that Craig claims it covers. So he's also claimed that he has a patent on NFTs, for example.
Mm-hmm.
Well, okay, there are some that involve off-chain things being registered on-chain, and it sounds sort of vaguely similar to NFTs, but they always have a weird feature in there that means that, well, okay, you could infringe that, but why would you want to? You just don't need to add that feature.
Or you could do it a different way.
Yeah, exactly. You go, well, if I'm in danger of infringing this weird feature here, I can just do it slightly differently, and I wouldn't be infringing.
He either genuinely thinks that the ideas he has had have been carried out and fully back up his claim. So if he says, right, Ethereum infringed my patent on NFTs, he either genuinely thinks his patent covers everything that he's going to sue for, or he's completely bullshitting for whatever reason. Are you able to cast an opinion onto which of those you think is the more accurate?
I can say my opinion based on the very specific thing that he said about the opposition that I wrote but Arthur filed. And he did mention on Twitter, someone asked him, or someone pointed out, these jokers have filed an opposition. So, and all he had to say was, it's a joke. They're just saying what the examiner's already looked at. This is why I think Craig doesn't really know what's going on. He doesn't understand patent law, because he would have spotted this. It's a basic rule of European patent law that you're not allowed to add matter.
Well, that brings us neatly on to the opposition that you and Arthur have come up with together. So why don't you talk us through what this patent is and what you found that's wrong with it?
As I mentioned, I've been looking at what nChain have had granted from the EPO over the last year and a half. Really looking at if there's any low-hanging fruit, easy targets, whether this is they've patented something that's already known, so we've got some prior art. What I've been looking for is, well, are there any easy? I'm giving my game away really, but it doesn't really matter. Are there any easy targets that I can see? And having looked through however many dozens of these, this one popped up a few weeks ago, and I saw it, and knowing about how things work at the EPO, almost immediately after a few minutes, thought, oh dear, that one doesn't look good. Then I thought, well, someone should oppose this. The opposition that we've filed is a very specific attack involving Article 123 of the European Patent Convention, which is all about added matter. So it doesn't cite any prior art. We're not saying this is not new, this is not inventive. What we're saying is this has been amended in a way that adds matter that was not disclosed in the original application. It's one of the basics of patent law, that once you've filed something, you can't start changing the invention. You can't start adding things that you didn't put in the first place. That's just fair play. If you claim something specific and then you say 5 years down the line, oh, and actually it has this extra feature as well, but you didn't include that at the outset, that's adding matter and that's not allowed. So the attack is that during amendment, to get this patent granted, an amendment was made that shouldn't have been done. It added matter. It looked actually like an error made by the patent attorney, nothing that Craig has done, and it makes it, as far as I can see, fatally flawed. So when the European Patent Office grants a patent, there is a period of 9 months during which anyone of any standing can file an opposition. You just have to pay a €840 fee and state your case, whether it's I have some prior art that knocks this out, or something has been done that makes this invalid, like you've added matter, or even that the patent hasn't disclosed the invention in a way that makes it possible for someone to reproduce it. So anyone can file an opposition, and then that becomes a sort of legal case where you've got the opponent, the proprietor, and the EPO. Usually lasts about 18 months. Things go back and forth in writing, ends up in a hearing at the end, and the EPO decide whether the patent stands unamended or whether it has to be amended, or whether it's revoked.
And with your patent attorney hat on, not with your Craig Wright hat on, what do you think is the likely outcome for the opposition you have filed?
Without going into the detailed technical aspects of it, I think it's pretty much dead, because it's been amended to add matter to the independent claims, and that amendment can't be corrected after grant because it would broaden the claims. So on most of the claims, that is a fatal flaw. There's a small possibility on some of the other claims, that the last two claims 22 and 23, if anyone wants to look in enough detail, they can find the patent. There's a possibility that they might survive, but I think it's only a slim possibility. So I'm pretty confident that this is basically a zombie patent. This is already dead. It just doesn't realise.
Regarding this single issue then, did you say 18 months, or how long did you say this whole process would last for?
The EPO aim to get oppositions finished within 18 months, and that counts from the end of the opposition period. So in this one, the end of the opposition period is March next year. So unfortunately, even though we've filed it and we've paid the fee, nothing is going to happen until March, because the EPO will always wait until the end of the opposition, just in case someone else has filed one.
So 18 months from March next year?
From then. So it's, even though they have speeded up things considerably over the last few years, 18 months is still seems like a pretty long time to decide what's really quite a simple case in this one. The opposition has already been formally examined, so it is admissible. We've paid the fee. It meets the formal requirements. Sometime in March, the EPO will issue a communication to nChain's attorney, and then they will get 4 months to respond to that. Then we'll see what they think of the opposition, really. We could get a chance to respond to that, but we don't need to. The opposition division will then issue a summons to oral proceedings, probably with a preliminary opinion. So they'll tell both parties what their opinion is, non-binding, but we think it's valid, it's invalid, reasons, and they'll invite the parties to attend oral proceedings at the EPO to discuss it, and then the final decision will be made on the day of the hearing.
So let's look ahead. Let's say that you get the outcome that we're all hoping for and it gets booted. It's not exactly the start of a massive chain of dominoes that see all his patents kicked out or anything like that. I get the impression it would be quite embarrassing for them, to be honest, because they've put so much store in this, and to be kicked out for like a technical error, that's going to be a bit kind of chastening, isn't it?
Well, you could look at it one of two ways, I suppose. It could be an embarrassing error and somebody gets told off, or you could look at it in the sense that, I've looked at 57 of these patents and I've only found one with an error like this in it. So that's not a bad rate of success.
Yeah, that's true.
I mean, it shouldn't happen. As a patent attorney, I would be extremely embarrassed if I made that amendment and made the patent invalid as a result. But they might take the view that, well, we've filed a divisional anyway, so they've got another application pending. This one, by the way, is a group of 3 or 4 applications that relates to Craig's crackpot idea of Bitcoin being Turing complete. You know all about that, Arthur, or have you read about that?
No, yeah, of course I know about the Turing complete claims and the plagiarized papers that he wrote about them, which is a bunch of nonsense. But yeah, please go ahead and explain.
This patent is one of 3 that was granted recently that cover different aspects of supposedly making Bitcoin Turing complete by adding an off-chain agent, which basically looks for locking and unlocking scripts. Locking and unlocking script itself just does a logical test, so it has Boolean inputs and does something logical. In this case, it's an XOR operation, but they've covered various other ones. And XOR was one of the options in the original Bitcoin protocol, but it was disabled shortly after. So it basically covers what was inherent in the original Bitcoin protocol. So you have the off-chain agent, which effectively is Bitcoin Core, the software that runs it. You've got locking scripts, unlocking scripts, and the idea of it being Turing complete is that you can then use the unlocking, unlocking script to do the logical operation, and then the agent does the other bits which the script doesn't do, like loops. It's bonkers. I can't see anyone infringing this. It seems like these are particular vanity projects of Craig's. And these ones are ones where Craig is the only inventor. So I think this is even more of a vanity project of Craig's, where he just wants this one patented because it's one of his bugbears or claims that he likes to make. And if he can get a patent for something that says Bitcoin is Turing complete, then he can start waving it around.
Yeah.
And say, look, Nick Szabo, I told you in 2015 or whenever it was, I saw the video, and Nick Szabo is looking a bit puzzled about Craig saying,
yes,
Bitcoin is Turing complete.
Yeah, I remember that. It does seem to me that this is just another extension of his desire to give the impression that he knows more about blockchain and Bitcoin than anybody else. But again, as you said, once you look under the surface, you look into it, it just crumbles, and it's just, there's no substance to it whatsoever. And I find it amazing that he is essentially, in his words, he's going to war on the back of these patents. And it seems to me that over the next 5 years or however long it's going to be, it's just going to be one embarrassment after another, because he might get some slight successes if there's one blockchain that happens to, maybe by accident, have copied something he's patented. He might get some victory there. But do you think then that this is just going to be a 5-year process of pain for him?
I don't know. I'd be surprised if he lasts that long. I wonder whether this opposition will even get to the end while Craig's still operating, or nChain is still operating. I don't know. If we could think ahead.
Yes, let's pretend nothing else is happening. It's only the patent cases that he's got. Do you think that this is just going to go nowhere?
Well, this is one of the questions that is open, really. What would it look like if nChain were winning? And obviously the BSV should be going up. They should be announcing big licensing deals with big companies, because it'd be no use for them suing small players and just threatening them with infringement like a normal patent troll. They need to go for the big boys. If they start waving their patents around, from what we've seen, the big boys will go, no. This is either, we don't even infringe this because you've added this feature here, or We've got some prior art on that, and you don't stand a chance. Like you say, they might have accidentally covered something that turns out to be really useful. I think that's probably their best shot. But the chances of that happening, don't know. They might have had some amazing genius inventor there that's it won't be Craig, but some other inventor that's from nChain might have come up with something really good. And I've not recognised it, and other people haven't, and eventually someone might spot it and go, hang on, this is what such and such a company is using, and then that will save nChain because it will be worth billions. So just thinking that might happen.
So just to close things off, do you plan to start looking, because obviously they're getting patents filed, on a semi-regular basis. Do you plan to keep looking through as soon as you can the new patents that get filed for more of the low-hanging fruit, as you say?
Well, I'm keeping a spreadsheet of all the ones that get granted by the EPO. So that's public knowledge. I'm keeping that annotated, and that's a sort of progress update on where things stand. So I'm keeping an eye on a fairly regular basis. I think the other two Turing complete type patents might be interesting to look at from a novelty inventive step attack viewpoint. Like I said, they would stand less of a chance of knocking it out completely. But I'm fairly sure that they're on shaky ground, because they're effectively claiming things that are inherent in how the Bitcoin core and script operates. But yeah, we'll see. If anyone's interested in attacking those, then I'm happy to help out.
We did not properly discuss how nChain can actually patent troll their way through the Bitcoin industry or blockchain industry. What can they do, and why is this moment, this opposition at this moment important to do? I mean, if you get a patent kicked out, obviously they cannot patent troll anymore. But at the moment, and that's why this moment is so important for this, to do an opposition, and the more we can do, the better. But the patent trolling is they will start calling companies, nChain, and claim that another party is infringing copyright. And then what can they do? They can avoid a legal case by paying license fees, or they can change the product and take out the feature that is infringing, I guess. But the thing is, we do this for the parties that are not very experienced with this, and they start paying license fees. That's right, huh?
Yeah, the important point really is people who might be on the receiving end of trolling from nChain, if that does happen, need to be aware that there are things that they can do. They don't just have to give in. So if they're aware of you, Arthur, it's a matter of, I know a man who can help.
Yeah.
That sort of thing. It's making those links to people who might be on the receiving end of threats, and getting them aware that there are things that they can do. Often it's just a matter of writing back to nChain if they're alleging infringement and just say, no, it doesn't, because various reasons. We don't do this because we don't have this particular feature that you've got in claim one of your patents.
Yeah.
And it's all basic stuff for a patent attorney, but it might be, you can obfuscate things an awful lot if you're the patentee and start throwing your weight around.
Yeah, but I don't think nChain will get away with it when they try to patent troll big parties like IBM, Microsoft, Ethereum, and then I already lean back and just let the show begin, and I'll have my popcorn and wait for nChain to be kicked out of the courtroom about that stuff. It's a no-brainer.
I looked up actually the quote from Sun Tzu. Never interrupt your enemy when he's making a mistake. So it may well just come down to that.
Yeah, that is a fantastic place to end. Well, David, you've given us a really informative insight into the patent wars and what's to come. So thank you so much for that.
You're welcome. It was fun. Thank you.
Great stuff. And of course, we'll be keeping everyone updated with developments on the patent front. And we'd love to have you on again for further updates in the future.
Great. I'd be happy to.
Thank you both, and hopefully we'll catch up next year.
All right. Bye-bye.
Cheers.
Thank you for listening to this episode of Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, and huge thanks to our guest, David Pearce. For details on how to contribute to the opposing of Craig Wright's patents, your best bet is to find David on Twitter at TuffDTheCat, or find Arthur at Arthur_Van_Pelt for details on their next target. If you'd like to get access to our monthly episodes a few days earlier, plus access to all our bonus content and announcements of what we have in store, you can do so by joining the Dr. Bitcoin Supporters Club. For more information on how to do this, please head to our website drbitcoinpod.com. That's drbitcoinpod.com. Don't forget to subscribe to the podcast on your app of choice, and if you enjoyed what you heard, please consider leaving us a rating or a review wherever you listen in order to get our message out to as many people as possible. Thanks very much for listening, and we'll speak to you again soon.
You've been listening to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Written by Mark Hunter, with additional material by Arthur Van Pelt. Editing and production by Mark Hunter. This has been a Contented Media production.